please go on about the false factual findings. Could you give us some examples of those?
Sure. I think, Lawrence, the most obvious one that your many listeners will recognize right away is the false finding in the Citizens United decision that nobody needed to worry about corruption because all of the unlimited spending that decision would unleash would be transparent, that the public could evaluate the motive of the big donors because they would know who they were. Well, that's what the Supreme Court said, but here we are, multiple billions of dollars in secret money, proving them wrong, and yet they won't go back and reconsider that false fact. Without that false fact, the decision falls apart because it was essential to the logic of that case.
So are most of the false facts predictive of what will happen if we rule a certain way, or are some of them actually false statements about things that have already occurred?
I think it's sort of, when you're constructing an opinion, it has a logical, analytical shape to it. And in order to get where the Supreme Court wants to go, they often have to fill in facts that justify and support the arguments and the logic of their decision. And what they don't do is follow the rules, which are you should look at the congressional record for facts that Congress found if you're evaluating the support for a statute, or you should look at the judicial facts that trial courts found if you're looking at the facts that support a judicial decision. Whichever way you're looking, the American system of justice puts the fact-finding elsewhere than in the Supreme Court, and for very good reason. And yet you see these false facts continuing to pop up to prop up decisions that produce results that the big donors want. And you can go through case after case after case. And if you look forward, what they just did in Dobbs and in Bruen, the anti-choice and pro-gun decisions, was to say we're going to completely renovate the way we look at the law in these areas. And we're going to look instead at history and tradition, which means we get to make up our own facts about what history is and what tradition says. And that's why historians had such a field day making fun of the false historical facts that they found in those decisions. So it's a very broad pattern in the Supreme Court's political decision making.
Yeah, I mean, on the Dobbs decision, when I saw that they were quoting from Old English common law, pre-colonial times, to English prosecutors and judges, I just immediately said, let's search and see how involved they were in witch trials. Because if you were practicing law in England at that time, there's a good chance. And of course, both of them were judges in witch trials.
Witches were a big deal back then to them.
Yeah, and both of them were witch prosecutors, and both of them believed witches should be put to death. And it was their view of abortion that Justice Alito wanted us to adopt in the 21st century.
Yeah, we have an American system of justice that is a very proven mechanism for making sure that facts are truthful. And that is that you develop them in the trial court where the two parties can fight with each other over the facts, where a neutral judge makes a decision. And if the neutral judge gets it wrong, an appellate court can say, hey, you got the facts wrong, but then it's supposed to send it back to the trial court to get the facts right. You don't wait until you've had the district court trial and the circuit court appeal and the arguments in the Supreme Court. And at the end of the process, when nobody can say another word, that's when you parachute in a whole boatload of false facts. That's not the way the system is supposed to work. For hundreds of years, it has not worked that way. And so this is a really novel trick that the Roberts Court has pulled. And it's so novel that, frankly, academia and lower courts haven't figured out a way to deal with it yet because it's a new thing.